as best as possible. Amen.
Thank you, Senator Longmore. Colleagues, Ms. McCarthy, do we have apologies for absence?
No, Minister, we don't have any apologies.
Okay, thank you.
I'm seeing a lateness from Minister Chuck. Says he will join us late because he's in another meeting.
Okay, very good, very good. Thank you, thank you. So colleagues, ladies and gentlemen, as usual, I open with brief remarks. We have certainly, again, I will repeat, come a far way from the initial tabling of the bill to where we are today. We are not at the end of the committee stage yet, but in very short order, we will be. All our efforts underscore commitment to destabilizing the issue of sexual harassment. Cannot overstate my gratitude to all involved in this process, regardless of the specific role you play. Your dedication speaks to the urgent need for the operationalization of this legislation. As is customary, our work is being carried live on PBCJ, on cable, and online. I ask that you put your cameras on when you speak, and if it is possible for you to keep your cameras on, it would even be that much better for television and for the audience that's viewing us. So at this point, before we resume from clause 10 of the report, I want to thank Senator Gale for chairing, completing the chairing of the meeting last time we met, and to thank him for the support that he's giving me as chair. I also want to thank the technical team, and at this point to ask committee members to bear in mind that this exercise has to be completed in short order. This meeting is an extended meeting, as I'm hoping that at the end of the day, we would have completed the report. We're gonna start by looking at the areas where we have not yet made decisions, and to see how we can arrive at decisions expeditiously. I also want to get the feel of the committee members if they would want us to take a break during the course of the day, maybe at about 1:30, and then we resume at 2:30, and we continue until 5 or 6 p.m., which hopefully by then we would have completed this report. I don't know if that will create a problem for the technical team and for our legal team, but I invite comments at this time if this approach is okay for everyone. So I invite comments here, if that's how we can proceed. MP Brownberg, please go ahead.
Thank you. Good morning, Minister. Good morning, Minister. Good morning, everybody. Minister, I did know that it was an extended meeting. Unfortunately, though, if we break at 1:30, that's when I will have to be. I have some other pressing engagements in the constituency that I can't really put on past. So that's not that.
Okay, thank you, MP Brownberg. Anyone else would wish to comment? Senator Gale, you would
Minister, I had a meeting at 2. I am now advised that that meeting has been pushed to 3:30. So I don't have a difficulty with the break for the team at 1:30 and resume at 2:30, but I have a challenge that I would have to leave at 3:30 and then get back into this meeting.
Hi, Minister.
Yeah, hi. MP Crawford. Yes, all right. Well, maybe then we could push along until 3 p.m. or 2:30, Senator Gale, so that you could stay on as long as you can. And then we see where we reach. We can determine if we take a break at that point and come back and get another maybe 2 hours in, 2.5 hours, because I think we're at a point where we have to.
But remember, Minister, there might be persons who might want to break in between the long span.
Yes.
So I really believe that it would be better for us to break at about 1:30 and resume.
Yes.
Because these meetings can take a toll. I'm just saying that.
All right. And we resume at maybe we break at 1:30, so maybe we could take a shorter break.
Right.
Right.
Yes, perhaps half an hour, because you
Yes.
don't want to keep people away too long to get back in the rhythm.
Right. And we come back at 2. All right, wonderful. All right, so as Ms. Grant, I'm gonna ask you if we could look at the outstanding areas first and make some decisions there. And then we can go through the report where we left off at clause 10, just to do a final read. So we'll start with the outstanding areas. Ms. Grant? Are you there?
Yes, Minister, give me a moment to.
Okay, sure. So in the meantime, I will indicate that I'll just go through the outstanding areas. Clause 10, that's page 25. Clause 11, which is on page 26. Clause 13, page 28. Clause 25, page 33. All right, those are the outstanding areas where we have to make decisions.
So far, Minister.
So far, okay. All right. So Ms. Grant, you're actually identifying other areas. And you will provide me with those?
Yes, I will. They're not a lot, really.
Yes.
Between myself and Mrs. McCarthy, we counted maybe about 9.
Yes.
So it's not that bad.
Okay, fine. All right, so you're going to put up these sections, please, so we can share. Okay. So in relation to clause 10, your committee also notes the observation that the Act does not highlight criteria, selection process, performance monitoring, or communication with the public on performance of the tribunal. and the suggestion that there should be a maximum turnaround time for the cases to be heard and decided on at the tribunal. We note the proposal for both the tribunal members and the authorized officers who support them to be trained and certified in matters in matters pertaining to sexual harassment, gender awareness, and sensitivity, diversity and inclusion, and intersectionality. Does the committee accept this recommendation or not accept it? Invite comments. Senator Campbell Rodriguez. And please put your camera on. Thank you.
Thank you, Minister. Just to clarify, that last sentence you read, what exactly do we mean by intersectionality? Or what is meant by that?
Ms. Grant? Oh, go ahead, Senator Gale. You want to respond to that?
Not particular due to responding to what is meant by intersectionality, but more, Chair, looking at what the committee observed. First of all, let me deal with the question
Sorry. Can I finish my observations first?
Oh, sure. I'm sorry. My apologies.
Yeah, man. So outside of thank you, Senator Gale. Outside of that, Minister, it's also that the section of it which says communication with the public on performance of the tribunal. I'm not sure that's something that we should try to do or aim to do. Maybe what can happen is that there is a website or somewhere on the ministry's website where the reports from the tribunal are, but then you have to deal with the issues of confidentiality with the persons involved in the cases. So that section I definitely think is a little tricky. So I'm not particularly keen on that. I like the idea though that we need a maximum turnaround, well, I would say a minimum turnaround time for cases to be heard and decided at the tribunal. I would change maximum to, well, I guess it's maximum time. The length of time, the longest length of time for which cases should be heard and decided on by the tribunal. I really think we should consider that part, but not the part about communication with the public on the performance. And the other bits, which are criteria, selection process, and performance, I do support those ideas as well. But I'd really love to understand what intersectionality means in this context.
Okay, Senator Gale, did you want to continue?
Yes.
Comments, and then I will recognize MP Angela Brownberg.
So we can make observations in terms of what should represent itself in the course of the action of the tribunal. But it's not everything that we can really legislate. And we should give the tribunal the opportunity to present its own rules. In terms of, and this has to deal with the question of selection process, performance, monitoring, and communication. Those are matters that the tribunal should really deal with and not that we placed into law. Now, regarding the turnaround time, the Industrial Disputes Tribunal, there is that established turnaround time in terms of that tribunal making an award within 21 days. And the tribunal also have the right to indicate that if it requires more time outside of the 21 days, then the parties involved should be communicated on. The training training in these particular areas, again, it's a recommendation. It is a good recommendation, but it's a recommendation that has to be determined and encouraged, not only by the tribunal, but the ministry involved, and not necessarily that we're going to entrench such provisions in law. That would be my position.
Thank you, Senator Gale. MP Brownberg?
Thank you, Minister. So I was looking at what is there. So as with others, I certainly would like to see a maximum turnaround time for cases. I also believe that it is important. We are in an era where transparency is a little bit different than it used to be. A transparency.
Dr. Brownberg, there is a noise in the background. Yeah. Is there sound?
Are you still hearing it? I thought I'd so
yes.
Let me turn off and see.
Yes. Okay, go ahead. While we wait for MP Brownberg to come back on, I just want to highlight the fact that Clause 10 does highlight the election process. Tribunal should be allowed to make its own rules, read maximum turnaround time for cases. And this does not need to be placed in the legislation. As it relates to training, it should be a feature of appointment as was agreed on in the last meeting, that potential appointees undergo training in matters pertaining to sexual harassment. Those are my comments in guiding the committee, and I ask Dr. Angela Brownberg to continue her comment.
Thank you. Thank you, Minister. Sorry for that. It just tells you the noise I have to deal with every day at home. I believe that, as you have said, Minister, some of these issues are actually addressed in the Act. But in terms of communication with the public on performance of the tribunal, I believe it's important. And I don't believe that communication means that you have to get into the granular details. I believe some summary details would be number of cases, number resolved, kind of stuff is what would be, and they would determine what is the appropriate depth or detail that is required for the public. But I do believe that in this era of transparency, something like that is not unreasonable to ask for.
All right, so can we make a decision? Can we make the decision that it is not necessary for this to be placed in the legislation? That the tribunal should be allowed to make its own rules, the maximum turnaround time for cases, and that as it relates to training, that it was agreed on in the last meeting that potential appointees undergo training in matters pertaining to sexual harassment. Ms. Grant, I see Ms. Grant, she has her hand up. Go ahead, Ms. Grant.
Yes, Minister, I just want to provide a little bit of context here, because if it can have the effect of confusing some. This comment came from the PSOJ in relation, it was put on the matrix. The comment that they made was in relation to this clause, and that's a comment that has really generated the discussion now. However, clause 10, as we all know, does not relate to the tribunal. It really relates to authorized officers and their roles and functions. So whatever decision that the committee comes to, I just like to point out, Minister, that comment and whatever decision should probably be placed in the section that relates to the tribunal, because as it is now, even though this comment was made by PSOJ under this clause, in terms of congruency in the report, it doesn't properly belong under 10 because 10 doesn't have anything to do with the tribunal. So I just wanted to put that out there.
Okay, thank you, Ms. Grant. Dr. Brown-Burke, you wanted to make a further comment?
I'm sorry, my hand was still up, but just in terms of understanding what was just said, is that therefore that whatever the agreement is for the committee at this stage, as it relates to the tribunal, then we would place it there. And then we would look at what pertains here to the decision that we're making. And then secondly, Minister, we did not answer the question from Senator Rodriguez Campbell as it relates to intersectionality. My understanding of intersectionality here is where the issue of sexual harassment, gender awareness and sensitivity, diversity and inclusion needs or overlaps.
Mm-hmm. Okay, well, what I think we should do at this point is focus on the decision we will make in relation to the recommendation in clause 10. And I think we should be guided here by Ms. Grant in relation to the tribunal and what it should be allowed to do in setting its own rules and its maximum turnaround time, and also regarding training, which was agreed on in the last meeting, that they would undergo training, potential appointees would undergo training in matters pertaining to sexual harassment. So I'd just like to have a decision here. I don't know if anyone from other members of the legal team would want to make a comment here, or if we can just proceed to make a decision and move on to the next clause, if members are so minded. All right, so can we agree that we will not accept the recommendation based on the explanation that I gave, based on details that we have from the last meeting? All right, so we can move on now to clause 11.
I'm sorry, Chair.
Yes.
Just and in that same vein, to say that it should properly be moved under clause 11, which deals with the establishment of the tribunal.
Okay.
Agreed.
Agreed. Okay, fine.
Yeah.
All right, so we go now to clause 11. And you want to take us there, Ms. Grant?
Give me a moment, Chair.
I'm sorry, Minister, for 10.
Yes.
There is a note, yes, it's in blue, but then I saw the last sentence highlighted with some question signs after it. That's the one about also noting the observation that the option of mediation was not included in the bill and the proposal to include the option therein for appropriate cases. But I guess that also would be for the tribunal.
Yes.
Yes, okay.
Okay. All right. Ms. Grant, so
I'm sorry, Chair. On the point that Dr. Brownberg made on the highlight in yellow, it's on the screen here.
Yes.
As McCarthy has, we also agree that the functions of the authorized officer should be outlined, and she has question marks. I don't know if that has, well, I think this is the most recent version, but I don't know if that's still something that she wants to be looked at.
Ms. McCarthy?
I had left it with the question signs, Minister, because I'm not sure if Mrs. Seeley Brown was going to outline it for the report, or we just say it's going to be outlined in the bill as a part of the amendments.
Okay, Mrs. Seeley Brown, could you respond, please?
I'm not sure I'm understanding, Chair.
Well, perhaps I can.
I'm not sure I'm understanding what is being required, Chair.
perhaps I can help, Chair. In the last meeting that we had, Mrs. Celia Brown, we had said that the authorized officers, that their functions would be tantamount to, for example, those that go from the utility companies to say, oh, you're allowed to do this and stuff and all of that. So I think what Mrs. McCarthy wants to find out if, so it was raised that that should be in 10, especially given that the investigating arm of it would no longer be a duty that they would need to perform. So I think what she wants to find out is if that's going to be put in the legislation, and that's the impression I had gotten, that it would be put under that clause. I think that's the question.
I'm thinking, yes, you would have to realign their functions and state it clearly in clause 10.
Okay, thank you. So members, it's clear, Dr. Brownberg? Thank you, Mrs. Celia Brown. Okay. Okay, so all right, so in relation to clause 11 and the recommendation, we also note the proposal for authorized officers and the full tribunal to be thoroughly sensitized on sexual harassment issues. The committee should accept that. And I think we all will agree here.
Based on the previous recommendations, Chair, this would just simply fall in line.
Yes.
That the authorized officers too would undergo some sort of training.
That's correct. All right, so we can move on. Now we go on to clause 13, Ms. Grant. Right. So I read, we note the proposal that the bill also makes provision for the following in relation to the tribunal. What would happen if one or more of the members of the panel dies, become incapacitated, or ceases to be a member of the tribunal after the panel commences hearing a complaint, but before an award or decision has been handed down? How the panel would make a decision after hearing a complaint, that is, whether decisions ought to be taken by voting and whether the decision of the panel ought to be made by the majority of its members. Whether the chairperson should make a decision if there is deadlock, and whether the Arbitration Act will be applicable to the proceedings of the tribunal. I will invite Senator Gale to start all the discussions here and invite other comments, and then I will.
Chair, and maybe Mrs. Celia Brown and Solgen can remind me, but I've seen in other legislations that speaks to the role and functioning of tribunals, where these rules apply in terms of if a panel member dies or leaves, what would happen? I've seen it in other legislations, and maybe we could import those rules here in this piece of legislation, where it specifically deals with the functioning of the tribunal and what would happen in these circumstances. I was trying to search for one. I couldn't find it at the time when you called on me.
Okay.
But I'll be guided by the technical team in this regard.
Okay. I think Mrs. Celia Brown, Yeah, directed that question to Mrs. Celia Brown.
Chair, good morning again to you and members.
Yes, Celia, how are you?
Eyes are open, Minister. Eyes
Yeah.
are open. Thanks. Yes, it is true that there are that these are rules that can be incorporated. There are times when, so if you have a panel of 3 and one member, something happens and that member can no longer function as a member of the tribunal, that, and especially if the matter is already progressing to a certain stage, there are rules that can allow for the remaining 2 members to continue and hand down a valid decision. I'm aware of those types of rules. It's usually a little different if it's just one person. And if that one person becomes incapacitated, normally it means you'd have to start over, de novo. But since this is a panel, we do have provisions that can be put in to address this situation.
Okay, so all right, so members agree that that would be taken into consideration and the appropriate wording be put here.
You see how Soldier said nice and pretty, Minister. I couldn't do it like that.
Right, and in relation to deadlock, there I think this was discussed prior and agreed. The committee had agreed that no deadlock could exist in a 3-member panel, and that the position was already agreed on in the earlier part of clause 13. So we would have addressed all the issues raised there. Am I correct, Ms. Grant?
Yes, Chair.
All right, so we can move on, committee members. Ms. McCarthy, it's clear to you?
Yes, Minister. Yes, it is.
Okay, good. Thank you. All right, so we're going to now move on to clause 25, page 33. Clause 25.
Minister, I'm sorry, Minister, clause 24.
What we're trying to do here is to go to the clauses that where we made no decisions and get those out of the way. And then we go through.
And then you go back through the entire thing, Minister,
correct.
because you were passing clause 24, and the wording that was there is one that made me uncomfortable. I had wanted to raise it.
So we will go through that. We just wanted, the way we did not make decisions, we want to move through quickly to make decisions. And then we can go through the report where we left off last meeting and fine tune. Yeah. All right, so your committee notes the proposal that a simple but comprehensive complaint, in parentheses, form should be set out in a schedule in the bill. It should also be stated that a complaint can be lodged by someone other than the complainant on behalf of a complainant, such as a trade unionist or caregiver. I invite comments here from the committee. Any comments? I can provide some guidance. As a start, the committee need not accept this recommendation if the complaint form is going to be set out in the schedule to assist complainants or complainants in putting their complaint together. It certainly would be necessary then to have education on the use of the form, and officers that the tribunal can appoint can assist where necessary. So that would be my guidance here. So we need not accept this recommendation if the form is going to be set out in the schedule. Senator Campbell Rodriguez, please go ahead.
Just, thanks, Minister. Clarification needed here. There are two things mentioned here. One, the recommendation, the proposal that a form be put in the schedule. And secondly, that a complaint can be lodged by someone other than the complainant. The context you just gave a while ago addresses the first one about the form. And I agree with what you're saying wholeheartedly. But the second part, that it can be lodged by someone other than the complainant.
Yes, we need to make a decision on that.
I'm in support of it, but what I wonder is the phrasing of it, because as phrased here, on behalf of a complainant, such as a trade unionist or a caregiver, it sort of puts a limit on it. And I'm wondering if the drafters would be looking at phrasing it differently, or can it be left like that because that's how the law is read? I would need some clarification, if you don't mind, Madam Chair.
Thank you, Senator Campbell Rodriguez. Senator Gale?
Chair, let me first declare that the fact that a trade union is being suggested there, I don't believe I was the one who represented that. But I certainly agree that in the schedule, you should have this form presented in such a way that would capture the information that is required for the complaint to be made. I also agree that someone can assist the complainant in making the complaint or filling out the form. But we may get into some difficulty where we start listing who can make the complaint. And the list may go on. So I wouldn't prescribe that this part where it is suggesting that trade unionists or caregivers or whomsoever can make the complaint. What we want is the complaint to be submitted in the format that is required, that would be part of the prescribed schedule. That would be my position on this.
Thank you, Senator Gale. I see Mr. Whittle, MP Whittle. Could you go ahead and make your comment?
No, I wanted to go back to the clause 13, I think, with regards to deadlock. We have decided that there could be no deadlock on a three-member panel.
Whittle, please. Mr. Whittle, can you put your camera on and I ask you to just repeat what you said? Thanks. Unless you have a difficulty putting your camera on, that's fine. But could you repeat what you said? Thank you. MP Whittle, you there? MP Whittle?
Are you hearing me?
I'm hearing you now. You are unable to put your camera on?
Yes.
All right, no problem. Yes, go ahead.
Yes. I was referring as it. Hello?
Yes, go ahead. We're listening.
Yes, I was referring to clause 13. issue of a deadlock, and the committee has agreed that there could be no deadlock. But I was looking at the issue of that we just discussed in relation to if one of the persons on the panel would have mentioned with me that those two persons would make
So MP Witter, you're questioning that decision. We're not hearing it clearly.
I think that there could be in that case.
MP Witter, we are not hearing it clearly, but I'm going to just ask the SG. I think she get a sense of what you're. Yes.
Yes.
Go ahead, SG.
I'm not sure if MP Witter realizes there's a connectivity issue, so we're not hearing you clearly. But I think the issue is that there could be a deadlock if you are reduced to only 2 members of the tribunal. I think
right, that's what.
Okay.
Perhaps you should allow MP Witter to speak without attempting to turn on the video. Sometimes the use of the video when you're not in a steady place forces you to not hear properly. It affects the connectivity.
His video is not on. It's not on. I think he's having a connectivity issue, but we now get a sense for what he's saying. I'll ask the SG to comment here.
Normally, we don't usually address that situation, but I can see the concern that if one member becomes incapacitated and you reduce the tribunal, the panel to now 2 persons, that you could possibly have a deadlock. I'd have to look to see how that is addressed elsewhere, because I can't recall right now if that usually is addressed. And I'm wondering if that also could be something done by the rules that the tribunal will have to make, because they will have to make rules. So if you don't mind to give me a few minutes, maybe I can just discuss off camera with Mrs. Celia Brown as well.
And just to bear in mind that, I mean, we would have seen this situation occurring at the Industrial Disputes Tribunal. And what would happen is where another member from another division would be called in to ensure that you still have the representation of 3. Determinations would also be made whether or not there's a continuation of the proceedings or the proceedings would have to start over. But there is no decision that would have been made where a 2-member panel would make that decision.
Just for clarity, we're dealing, just remember which clause, what page we're on now?
MP Brownbrook, I'm sorry?
I'm just asking just to be able to follow up. I mean, I don't know why I got lost a while ago. Which clause are we actually discussing now? Raised by
discussing clause
MP Witter.
Clause 25.
No, man, the one raised by MP Witter.
He would have gone back to a previous clause.
Gone back to clause. Yeah.
Maybe the clause 10.
Yeah.
That should have been clause 11.
Yes, I'm sorry. Yeah. All right. All right, so we await at SG. She is consulting, and SG will get back to us to advise how we treat with that in relation to someone other than the complainant making a complaint on behalf of a complainant. What is the decision there?
Madam Chair, I'm sorry, I just stepped away for 1 minute, but I think based on what I'd heard from Senator Gale and what I'd said, we're saying we agree with it, but we shouldn't be limiting it to trade unionists and caregivers, and we shouldn't try to list who can lodge a complaint on behalf of someone else, because we could get into trouble if we start to list it out. That was my understanding before I quickly stepped up.
All right, I'm not sure if the committee on a whole agrees that
I do.
someone other than the complainant, right, can lodge a complaint. I see Mrs. Celia Brown she has her hand up, and also Ms. Grant. So I'm going to ask them to comment. Please go ahead, Mrs. Celia Brown.
Thank you, Chair. In relation to the first issue, those are things that are normally left for incorporation into the rules of the tribunal, which they can make themselves. I was just having a look to the legislation after having a discussion with Mrs. Alden, and I realized that we didn't put in a provision to say that the tribunal may make its own rules and regulate its own proceedings. So maybe that is something that we can put in, and then those things can be incorporated in those rules. And I've seen in some other pieces of legislation where we have even gone further to say that these rules may even be published in the Gazette because of the nature of this tribunal for the information of the public. So I think that is something we can put in rather than try to put in, separate provisions for things that we are speaking of now, and we may not foresee everything that we should include. On this, in relation to the second issue, I'm not sure. I need to understand clearly the mischief behind wanting somebody to lodge a complaint on behalf of another person, especially when this legislation does not relate to children. And that is the only thing I can see. That is the only instance I can see where you may want to lodge a complaint on behalf of another person. So without more information, I can't say much more because I don't understand what is the mischief behind having a complaint being lodged by somebody on behalf of a complainant. Thank you.
Thank you, Mrs. Celia Brown. We have noted both comments. Ms. Grant?
Thank you, Chair. I was going to say almost the same thing that Mrs. Celia Brown just said about someone else other than the complainant lodging the complaint, and the position is the same. I don't think we should countenance that. This is it's a piece of legislation that we're dealing with consent, with people that can consent. So we did agree in previous meetings that it will relate from the age of consent onward. And one of the things that came up is, okay, how will people know how to go about making a complaint, what is to be included? And that is why we came up, the committee agreed rather, to the insertion of the form. Apart from that, the form, and if there's assistance needed to fill out the form, as Senator Gale said, I don't think we need to consider someone else other than the complainant lodging a complaint on the complainant's behalf. Because of the nature of the legislation, and it is not a legislation that deals with children. In cases where you have children, then someone else on the child's behalf can do that, but I don't think it needs to be considered here.
Thank you, Ms. Grant. I see MP Davis. Please go ahead.
Thank you, Chair. Good morning, and to all my colleagues as well. My point was in relation to having someone lodge a complaint on behalf of the complainant. I was trying to understand the rationale for so doing. In what scenario or in what situation would we need to do this? Because it really is so subjective that the complainant would be required to have a say in the initiation of this matter. And like I always do, I try to envisage a situation in which perhaps in a work situation where two employees perhaps share a cubicle, and maybe one observes an action that she deems to be sexual harassment, then perhaps that is what is being contemplated, where the complainant is perhaps afraid and then this other person who is aware of the situation wants to make a complaint, then I don't know if that is the scenario we're complaining. But even then, even if my kind friend is making an observation on my behalf, it would still require that I make a statement, because I don't know that any tribunal would be able to hear a matter where the complainant or the person aggrieved is not the one making the statement. And again, because the trade unionist was given as an example, I wondered too whether it was a situation where the employee lodged a complaint outside of the work setting and perhaps some other party or ministry is aware of it. And even then, I'd be hard pressed to see how, without the complainant, we could properly proceed. Again, if I'm to accept that those are the scenarios, then I would add that even if someone lodges the complaint, that it can't go any further without the complainant herself or himself giving another statement, or perhaps confirming in some way that this complaint is something that I want to proceed. I did not have the will, or was not brave enough, or was not secure enough to make it. But the complaint having been lodged, I now stand by it and I want it to proceed. That is perhaps the limited scenario in which I can see some other person other than the complainant lodging the complaint.
Thank you, MP Davis. Dr. Brownberg?
Thank you, Minister. I disagree fundamentally. And I believe that I could in fact seek circumstances where someone would want to make the complaint on behalf of the complainant. One, it could be, it's a written form. So maybe I would feel much more comfortable with somebody that I know who helps me fill out the form, for example, because I can't read as well. That's one scenario. We're talking about making the complaint, not necessarily when it happens, right? Because the complainant actually has some time within which to make it. And maybe every time I think of it, I am still so traumatized that I kind of really even need that kind of moral support in terms of doing it. I've seen other circumstances where there is a part on the form that says, was this filled out by you, for example, or was it filled out by someone else on your behalf? I do agree that we should not limit who is able to do it on behalf of the complainant. And where you place that, again, is another issue. I know that coming up in there is, in fact, the notion that the complainant is the only one who would be able to take the complaint any further. And I totally disagree. I disagree because I believe that what we're talking about would involve more than one person. It would involve the complainant, and it would also involve the individual that is accused of creating this breach in law. And at the very least, one of the things that in looking at laws that deal with whether it is sexual harassment or sexual offenses, we know that a weakness in many of our laws is that we do not allow someone else to also bring the case forward. And I believe, I would hate to see that is where we really are headed.
Thank you, Dr. Brown-Burke. I will go to Senator Gale, then MP Davis, and then I'll hear from Mrs. Seeley Brown.
Chair,
yeah.
We have a prescribed form that at the end of the day, the complainant is going to give consent to what is being put forward as a complaint. It doesn't matter who would assist that complainant in making the complaint. It could even be someone who is disabled and would require assistance. But at the end of the day, that complainant would have to give some sort of consent to establish before the tribunal that a complaint has been made. What I would have been concerned about and what I would have seen in scenarios where someone else who is maybe like a third party would be coming forward to making the complaint without the consent being given by the victim. And that is where I'm having a little gray area. And that's why on this prescribed form, the complainant must give consent, notwithstanding the fact that you may have someone who assists, notwithstanding the fact that you may have a situation where someone provides support or encouragement or even help you to understand how to fill out the form, the complainant must give consent. And that's my thinking on the matter. And I support the approach that would have been extended by Member Davis.
Thank you, Senator Gale. I will ask MP Davis to make further comments. She has her hand up.
Yes, thank you, Chair. And thank you, Senator Gale, which is the point I was going to make, that in relation to what MP Brownberg said, it is not that I'm opposed to assistance being given to complainants. What I wanted to underscore was and make a distinction between a complainant lodging the complaint and a complainant being assisted with a complaint. They're two fundamentally different things. So just to be clear, I'm not saying that the complainant should not be assisted. So all the scenarios outlined by Senator Brownberg, I quite agree with. But I'm saying, and I even gave the scenario, it's that someone makes an observation and forms a view that a complaint should be lodged and goes ahead without the permission or the knowledge of the complainant and makes this complaint before the tribunal. So what I'm saying in essence is the complainant should always be the person who, as Senator Gale says, signs the form, whether it is done with assistance, whether encouragement, whether to read or write, whatever the situation, we need the complainant to be the person who says, this has happened to me, because it is subjective. It is an unwelcome advance made to you, and it is how you feel about it that will determine whether or not there's a case. So I just wanted to clear that up. I think Senator Gale by far assisted to make that distinction. I thank you.
Thank you, MP Davis. I will now take Dr. Brownberg and then Mrs. Celia Brown. I see Dr. Longmore's hand up as well, and Mrs. McCarthy, who I think probably just needs some clarification here. Maybe I'll take Mrs. McCarthy. I see your hand up. You probably just need to get something clarified.
Thank you, Minister. Just wanted to remind Mrs. Celia Brown, based on what she said about the rules, that at clause 41, the committee had agreed some time ago that there would be procedural rules for the tribunal to include complaint forms, and these rules would be gazetted. So just a reminder that it was already discussed and decided in a previous meeting.
Thank you so much for that, Ms. McCarthy, Mrs. McCarthy.
Okay, so Mrs. Celia Brown, I'll come back to you. Let me hear from Dr. Angela Brownberg, who had her hand up. I don't see her hand up anymore. Dr. Brownberg?
No, Minister, that hand was up from when I spoke. I thought one of the admin would have taken it down.
All right.
I'm sorry, I just did.
All right, no problem. I'll take Dr. Longmore, and then I'll go to Mrs. Celia Brown.
Thank you, Chair. I apologize. I rebooted my laptop and my camera is not working, so my camera is not on. I just wanted to quickly just throw in an awareness point here with respect to the obligation for medical officers and certain other personnel who may be first contact for potential victims of harassment. And with respect to children, there's an obligation of reporting such situations. Now, I'm not sure if we are clear with respect to sexual harassment as probably interpreted by a professional, a psychologist, a psychiatrist, a general practitioner, and whether there is any obligation to report such. But I am definitely in agreement with Senator Gale with respect to the victim needing to give that consent for such a complaint be made. I'm just probably seeking the clarification from the technical team as to whether or not, as would obtain in other situations where there's an obligation for the practitioner to make said reports. But I would imagine that the complainants would have to give consent for such, and I think that is the direction that we should go with. Thank you, Chair.
Thank you, Senator Longmore. Mrs. Celia Brown, please go ahead.
Thank you, Chair. First of all, Chair, remember we have stated that we are inserting a prescribed form. So when it comes to making a complaint on that form, anybody can assist a complainant in making that complaint on that form. But Chair, for that complaint to go any further, to be heard by the tribunal or to be heard internally using the internal mechanisms of an employer or an institution, there must be a complainant. So I'm not saying that you can't have somebody assisting a complainant in making a complaint. We don't have to put that in the legislation. That can be done. But for that sexual harassment claim to go further, there must be a complainant chair. So that's just a distinction that I wanted to make in relation to that.
Thank you, Mrs. Celia Brown. I see Ms. McCarthy, your hand is up. Dr. Brownberg, your hand is up. Do you wish to make a comment?
Sorry, Minister, I should have taken it.
And Senator Longmore, see your hand up?
No, Chair. That's from my
just one thing, Chair. Just one other thing, Chair.
Okay, Mrs. Celia Brown.
Sorry, just to remind Dr. Longmore that remember this legislation does not apply to children. Remember, we had said earlier, unless the committee has changed its mind, that we were agreeing that the legislature was not going to relate to children. So
no, I wasn't speaking in context of children. I'm fully aware. But it's just whether or not in the event of a recognized harassment situation, if there is an obligation within our field to make that complaint. But even within that, consent would have to be had, and the complainant, the victim would, I think, need to give that consent for such.
But there's nothing in here that speaks to that obligation. And I know that obligation is, from what I've seen, that obligation is only placed in instances where an offense, like a criminal offense, may have been committed. Like I think it is you have those types of provisions, in your Child Care and Protection Act. I don't know that is applicable in this situation, Chair. But even if the committee can decide as a policy that that's the way you're going to go forward. But as the legislation currently stands, there's no obligation on any professional, any health practitioner, any professional to make a complaint to the tribunal or an employer on behalf of any person who's been sexually harassed.
Thank you, Mrs. Celia Brown.
Minister, I did raise my hand again. Oh, but I see some others. Okay.
Mrs. McCarthy, you have your hand up. You wanted some clarification here? Okay.
Sorry, Minister, I thought I'd taken it down. So sorry.
All right, good. I will recognize Senator Scott Motley, and then I'll go to Dr. Brownberg.
Thank you. Thank you, Chair. I'm using a device that I'm not accustomed to using. So yes, I think that would do it. So I wanted to make a comment on the whole discussion, although I joined late, to remind everybody that the definition of sexual harassment is the unwelcome sexual advance towards a person. And it is a person who must regard it as offensive or humiliating. And therefore, I agree with the opinion which has been expressed by Mrs. Seeley Brown to say that whereas somebody can help in filling out the form, which of course will be a prescribed form, there has to be a complainant going forward. The sexual advance does go a little further, but even though it does, because it has, it might include a demand for sex, for example, which might be overheard by somebody, it still has to fall, in my view, in the purview of an unwelcome sexual advance. Now, importantly, I think, in response to what Senator Longmore says, once it is that somebody else can see the impact or physical evidence or so, I think it takes it into a different realm. And I think at all times we need to go back to the intention of the legislation and the definition of the legislation. And so I do not believe that this is a matter where a complaint can be made on behalf of the complainant by any other person, as distinct from a complaint being laid or assisted, the person assisted. So the complaint form would have to be signed by the complainant. And I'm sure the form will have a provision where if the complainant is unable to sign, that can be noted and somebody can sign on their behalf. But at all times, we have to realize that this is a very subjective kind of test that we are using. And so the complainant has to play a very active role. Those are my thoughts, Chair.
Thank you, Senator Scott Marty. Dr. Brownberg?
Yes, thank you. Thank you very much, Minister. So just for clarity, and I believe that the distinction between laying the complaint, lodging the complaint, and the fact that the form can be filled out with assistance is certainly welcome. And that is a part of what I wanted to say there. The second comment, part of the comment that I had made in terms of continuing without a complaint really doesn't belong here. There is another clause, I was just kind of looking for it just now, which says that if the complainant does not want to go forward with the claim, that they can't proceed. And that it was a reference in part to that I was talking about in terms of, because we understand the laws, we understand the issues, we understand power play, and we sometimes know how some cases don't get followed through. And that was what I was making reference to. And I'm sure it will come back up because I'm sure there's a clause that speaks to that as well.
Thank you, Dr. Bromberg. I see Senator Scott Motley's hand up. You want to make a comment now, or you just didn't take your hand down?
Chair, I didn't take my hand down. I'll do so now.
Okay, good, thank you. So I'm now asking committee members regarding what is the decision in relation to someone lodging a complaint on behalf of someone. We need to make a decision here. We will not accept this recommendation. I want to get the feel from the committee. What is the position? We have to make a decision.
Has to be with the victim's consent and awareness, Chair. That's my opinion.
All right, so we're not accepting this recommendation, which speaks to the bill stating that a complaint can be lodged by someone other than the complainant. We're not accepting that. All right, if I hear no objection, I will consider that a decision. All right, thank you, members. All right, Ms. Grant? could you move to the next, which is same clause 25, page 34 of the report.
Again, Minister, the section in yellow.
We're going to come back to those, right? We just want
so
to.
we're only dealing with the ones in red at this point? We're only dealing with the ones in red at this point?
Dealing with the ones in red at this point, right? And then we now go through the report. Now, page 25 on clause 25 on page 34 of your report, we also note the observation that the Child Care and Protection Act and the Public Defender Interim Act both include provisions for a complaint to be made by a child, his parent, guardian, next friend, or person in loco parentis. Now, we did agree that persons under 16 years of age would be removed from the remit of this piece of legislation, and a provision would be inserted in the bill to indicate said decision. So this recommendation we would not accept. Agreed? Okay. Yes, we all agree. Thank you.
Yes, Chair.
Agreed, Chair.
Yes. All right. So now we go to clause 34.
Sorry, I'm so sorry to interrupt you while you're.
Yes, Grant, go ahead.
Right. I'm just looking here, going through on page 20, on clause 29. It's also in red. We had discussed it earlier about the, yes, Chair. We had discussed it earlier about what would happen if one of the members of the panel did and so on. And it's back here in 29 procedures to apply in relation to hearing conducted by a tribunal. So just to say that whatever decision would have made there
is relevant here.
Yes.
All right, so we can move on from clause 29 to clause 34. And we have clause 34, 1B. We note the observation regarding clause 34, 1B, 5, and how one would vary the termination of a contract or agreement to redress any loss or damage suffered by the complainant. All right, the committee now has to decide. All right, we note the proposal for the inclusion of provisions for dismissal and certain other actions in the bill. Ms. Grant, I'm going ahead of you.
No, Minister, is okay. Here it is.
Yes. So are members following me at this point?
So it would be two things in 34, Minister. The first one you read and this being the second.
Right. Okay, so we need to note, we note the proposal for the inclusion of provisions for dismissal and certain other actions in the bill, as well as the inclusion of provisions to prevent double awards for the same types of action. So we need to make decisions here on both matters. I'm inviting comments here. Any comments? Do we accept these recommendations or we don't? Ms. Grant, you may want to guide us here. Put it in context.
Sure, Minister. This was one of the concerns highlighted by the Ministry of Labor and Social Security in relation to 34 1B5 that deals with, give me a moment, please. It currently says a direction that the termination of a contract or agreement should be varied to redress any loss or damage suffered by the complainant. And the essence of their concern was how would this contract be varied or terminated as the case is in relation to 5? How you're going to vary it to redress any loss or damage suffered by the complainant? I recall in previous meetings, different things were mentioned by the committee. I think possibly it was scratched at one point, if my recollection can be relied on. It was being suggested that 5 would be best maybe subsumed in 2, in that 2 it's much broader than 5, but the committee did not arrive at any firm decision on it as to whether it should remain or subsumed or taken out altogether.
All right. So we need to make a decision if based on what you have just outlined. So I ask the committee members to make their input so we can make the decision at this point. Senator Gay,
Sure, can I just see clarity from Ms. Grant in terms of what exactly 5 is trying to achieve? Just for clarity in my mind. Ms. Grant.
Chair.
Yes.
Can I just ask Senator Gale, because I'm reading it and I'm wondering if it is addressing a situation where a person, an individual may have been terminated,
right,
because he made
the complaint.
A complaint. And so because the conditions for termination may have not been fair in that regard. And I'm wondering if this provision is out there to say that in cases where that has happened, the court can now redress any loss or damage that would have been suffered by the complainant in an instance such as that. That's the only how I can see you varying out or redressing a loss pursuant to the termination of a contract. So I mean, I don't know if it probably needs to be drafted a little clearer if that is the intent, but that's the only how I can see this particular provision working, and I would seek guidance from other members of the technical team as to how they see it, Chair.
Thank you, Mr. Celia Brown. You see how it is written. I was assuming, but it just was not clear in my mind. And it now tells me that if that were the situation, then there would be 2 avenues to treat with that termination. In another jurisdiction, being the Industrial Disputes Tribunal, but are we saying here that the tribunal in making an award can also reinstate or take into consideration damages in making it is just not so clear in my mind how it is written. And that's why I asked the question. But I made the same assumption that you would have put forward.
So do we accept or do we not?
Sorry, Chair, may I say something before you
Sure.
Yeah, I'm Senator Gale, and I'm hearing you. And remember, we had that long discussion before about how we would deal with reinstatement. And then when you look at subclause 2, it says that the tribunal may, in the making of an award under subsection 1B, which this falls under subsection 1B, take into consideration the injury to the complainant's feelings or humiliation suffered by the complainant. I think all of those things will be taken in consideration if you're even thinking of things like reinstatement and all of that. So as I'm saying, I don't know if it's a case where, Chair, if the committee is going to accept that the provision says that we may have to draft it a little clearer, or if we should just take it out, since it can probably be covered under. Well, I don't see If
Two,
that's meant, I don't see where else it can be covered, Chair, under what we
well, two would
Under
take
two.
into consideration, you know, the suffering, the
Yes,
damages
yes,
that
yes.
may have been
Yes,
incurred, the
yes,
emotional trauma, the
yes,
stress.
yes,
Two would deal with that.
yes.
That's
Yes,
very
yes, we
clear.
can. Yes, yes. So we can take it out, and if we satisfy that it is covered, Chair, on the subclause 2, or if we're going to leave it, if it's a case where you may want it to be drafted a little clearer, Chair.
So the decision, do we take it out?
Chair, I just wanted to say, while we contemplate that, looking at 5 and even looking at 4, let's say in that the person was, because of the complaint, they were terminated. That even in such a, and wrongfully so, that even in such a case, 4 would step in to provide relief, in my opinion, a direction that the respondent should pay to the complainant damages by way of compensation for any loss or damage suffered by reason of the conduct of the respondent.
All right, so that's 4.
Yes. All right.
5 now.
All right, so we can move on. We won't accept this. Correct? Ms. McCarthy?
Yes, Minister. So do we say does not accept the recommendation as clause 2.2 already addresses the matter?
Is that how it would be worded?
Ms. Grant?
Mrs. Celia Brown?
Well, I'm not clear. Is it that we're going to delete paragraph 5, Chair? Is that what we're saying? That we will take it out?
Yeah, isn't that what we're saying, Ms. Grant?
Okay.
Well, I don't know, Chair. I was just offering that I think 4 could also help. So if it's taken out, then 4 could assist to provide relief as well, since 5 is causing some amount of confusion.
Mm-hmm. And I also got that impression from Mrs. Celia Brown that it could be taken out based on her guidance.
Can be turned to contract or agreement as a result of a complaint made, or you can use what's your defect to say direction that the termination of a contract or agreement as a result of a complaint made in relation to sexual harassment should be varied to redress any loss or damage suffered by the complainant, if you want to make it clearer, or we can take it out. I mean,
so Mrs. Celia Brown, you think it may be useful to make it clearer?
Well, if what I have, sorry, Chair, I need to put on my camera. If what I have stated is really the intent of the provision, we can make it clearer.
Mm-hmm.
Or if members are comfortable that it is being covered, like what Senator Gale is saying, it is being covered, it can be covered under subsection 2 and 4 as this grant is contending, we can take it out.
Okay, so the decision is, are we comfortable that it's covered, or do we want to make it clearer?
It's just that, Chair, when you say if we want to make it clearer, then what would be that amendment to make it clearer?
You will have to you'll have to amend it. I mean, and I'm not drafting now to say that this termination of contract must have been as a result of a claim that was a sexual harassment claim that was made. So you've made a claim against a coworker or a supervisor or your employer, and because of that, your contract, your employment was terminated. But then you're gonna have to prove, you're claiming that your contract was terminated because your employment was terminated because as a result of that complaint. And so you're asking the court to, well, the court is going to take that into consideration now when they are looking at loss or damage suffered.
So let me just ask you a question. So the redress in this case would only be limited to loss or damages?
Well, that is
why not reinstatement? Or does another
But remember, Senator Gale, that we had a long discussion about that whole issue with reinstatement and whether it really should even be an option. Remember that long discussion that we had?
So all right. Just bear with me. I beg you, bear with me.
Maybe we should just take it out, Chair.
Yeah, I'm trying to look for my hand, but I can't find it. Could I just?
All right. So let me manage this now. I'm going to take Senator Scott Motley and then Mrs. Macedo.
Maybe you should take Mrs. Macedo first because she might shed some light.
All right, go ahead.
Thank you, Chair. I was just looking at the clause, and since it is causing us so much confusion and we're not so clear, I think that it's best to just delete it, bearing in mind that subparagraph 2 above talks about redress of any loss or damage suffered by the complainant, and also subparagraph 3, which speaks about the respondent giving a direction that the respondent should employ or re-employ the complainant. So I think that there's other forms of redress there. I'm concerned about subparagraph 5, because it is as though we're imposing on this contractual situation here, where we're saying that a direction that the termination of a contract or agreement should be varied to redress any loss or damage suffered by the complainant. So I'm just not sure that this is necessary when we have other sub-clauses that provide for redress and compensation. And well, I'm not sure if we're still going with reinstatement, but perhaps we are. It's there right now. So I'm not sure that this subparagraph 5 is necessary, and especially if it's causing confusion and we can't come to an agreement as to the interpretation of it.
Thank you. Thank you, Mrs. Macedo. I will take Senator Scott Motley now.
Thank you, Chair. I want to support what Mrs. Macedo is saying. And I think that the circumstances which might emerge are covered elsewhere. But I also feel that if we're going to be talking about termination of a contract and so on, or reinstatement, we have to remember that there's other recourse under other legislation as well, if the person decides to go that route or require reinstatement. They do have recourse elsewhere because the act is not restricting them to proceeding only under this piece of legislation. But I think that it is best that we delete it, because if it is a little confusing in terms of what the intent is, and it's unclear as to exactly how broad the remit of the tribunal would be, especially as they could address it elsewhere. So I agree with the recommendation that it should be deleted, Chair.
Thank you, Senator Scott Motley. Okay, so at this point, I'll ask Senator Gale
to agree to the deletion, Chair?
Yeah.
Yes, yes. It's not clear in my mind what it is seeking. It's not clear in my mind what the particular clause was seeking to achieve. And as a result of the others representing the matters, that they are flowing accordingly, I say we delete it.
Okay. All right. Thank you, Senator Gale. Senator Scott Motley, did you forget to take your hand down, or you want to make a further comment? Okay. Thank you. So the decision, Ms. Grant and Ms. McCarthy, it's clear to you what the decision is?
Yes, yes, Minister, that we're agreeing to delete clause 34(1)(b)(5.
Yes. Okay. All right. So we go on to the next decision that we need to make. And this is in relation to clause 38. I don't know if Ms. Grant, you could, I'm looking at my notes here. I don't know if you may want to go to clause 38 at this point. Members, I will read from my notes. Your committee also notes the observation regarding—
Sorry, Chair. I'm sorry, Chair. We didn't go back to the second part of 34 about the provisions for dismissal, double awards, and so. Remember, you had read that second part.
Oh, yes, yes. The proposal for the inclusion of provisions for dismissal and certain other actions in the bill, as well as the inclusion of provisions to prevent double awards for the same types of action. Ms. Grant, do you want to just take that and put in context so that members will have a full understanding and so we can make a decision?
Yes, Chair. So what happened in relation to this? I believe this is something that was referred to by PSOJ to say that that it's possible, especially in relation to C, that where it says make such other award as may be appropriate in relation to the complaint, that we could have a situation where we have double awards being made, and that we need to guard against that. I do recall in a previous meeting that the essence of that was saying that, I mean, the tribunal would, if they have already made an award in line with any 34(1)A, B1 to whatever the Roman numerals would now be, that certainly the tribunal would not go again to make a similar type of award. So, you know, that it's unlikely to happen in those cases. So include the proposal for dismissal. It was, the committee had looked at it, but was not clear if that needed to be included. So just in the name of context, Chair.
Okay, thank you, Ms. Grant. I think I would ask Mrs. Cedar Brown, what's her thoughts on this, if it needs to be included?
I don't know, Chair. I can't recall seeing provisions like this in other legislation. I'm gonna have to do some research and see how it's done. So I don't have a yes or no answer for you right now.
Mm-hmm.
I see the issue that I'm understanding the issue that they're raising, but I'm not sure right now how we can deal with it in the legislation. So let me I'm gonna have to do some research and see if it's, you know, how it's done in or if it's done in another place in any other legislation. I don't have an answer for that one, Chair.
All right, so you'd come back to us on that. I don't know if the SG has a comment here.
Yeah, I don't know if Mrs. Aldred has seen, because I can't remember seeing anything in other
SG?
legislation.
Mrs. Aldred? Senator
Yes,
Gayle?
sorry, Chair, just couldn't find my mouse. We'll have to get back to you as well. We'll get back to the committee as soon as possible.
Okay, thank you.
So, Chair,
yes.
what the PSOJ is suggesting here, they are seeking to guard against a tribunal making a double award.
Yes.
Now, if you look at the scheme of the types of awards that can be made, it is likely that the tribunal can make a double award in terms of, if they say, re-employ the individual, and also, in addition to re-employment, treat with damages.
Mm-hmm.
What C says is make such other award as may be appropriate in relation to the complainant. So the tribunal in its own mind might decide that the award it is making based on what would have been submitted is appropriate. I would be most concerned if we include in this legislation a clause that would seek to prevent a type of award being made, and that it would be exposed to challenge. And so we may put the tribunal in a very precarious position to defend the award that it would have made. And so in another dispensation, the challenge on a tribunal where the tribunal would have made an award not in keeping with law. So I'm a little wary about it.
All right, so
and I wouldn't include any clause to indicate such.
So you're inclined not to include this?
There you go.
And Senator Scott Motley?
Yes, Chair. I want to be very clear as to what Senator Gale is actually saying, and that I'm understanding that it is in relation to the powers of the tribunal to make any such other award as may be appropriate in relation to the complaint. Is that what Senator Gale is commenting on?
No, no, my comment was based on the fact that there is the thought by the PSOJ to make provisions to prevent double awards.
Right.
And so the tribunal must have that authority that would have been contained in all of 34, save and except the one that we have decided to take out.
Okay.
But especially C, where make such other award as may be appropriate in relation to the complainant. So the tribunal in its own mind, having reviewed the situation, must be able to determine the extent of the award that it makes in line with what is contained in clause 34.
So you are agreeing that 2 must remain. You had lost me somewhere in the middle.
That 2 must remain?
That 34, clause 34, 2. Sorry, clause 34, C, make such other award as may be appropriate in relation to the
Yes,
complaint.
man, it must remain. It must remain.
That was what, by the time you were finished, I was a little unclear as to how you felt about that. Because I support that.
No, what I was pointing to is this provision that is being suggested, that the inclusion of a provision to prevent double awards, because I don't know what that would look like.
Yes.
I don't know what that would be, how that would be written, and what it would expose the tribunal to.
I'm with you on that. Thank you for clarifying it for me.
Okay, good. And Senator Scott Motley, you agree? You agree with?
Yes, I do agree.
Okay, great. I will now take the SG. Mrs. Aldred?
Yes, thank you, Chair. So I was looking back because I wanted to even understand what was meant by a double award. Because tribunals can, for instance, impose, depending on what their rules and the law allows, it can impose, say, a sort of penalty, like, say, a fine, as well as impose restitution, as well as even costs. And I don't know if that is what is being contemplated or seen as a double award. It's not considered a double award. The award of the tribunal can take into account several components. So, to be honest, I'm not even clear what is meant by a double award. If the suggestion is being made that they can only do, for instance, in the list of things, only B1 or only B2, then I don't think that is something that the committee should support. So maybe it is I'm not understanding what is meant by a double award. I think that's where I'm having a little challenge.
Thank you, SG. Mrs. Scott Motley, Senator Scott Motley, your hand is up. Is that you want to make another comment?
Chair, you have to forgive me. I'm slow on that part. My hand is not up to take it down, but thank you for inquiring.
That's okay. All right. Members, may I recommend that we do not accept this recommendation?
Yes, Chair. Agreed.
Okay, members, all members agree?
Yes, Chair. Agreed.
Right. Excellent. Great. All
I
right.
agree.
Okay. Okay, Rhodamoy. All right. Now, clause 38 speaks to, it says, and I don't know, I'm going a little faster than Ms. Grant.
No, Chair, we never
Chair,
dealt with 37, 3B.
Before, Chair.
37, sorry.
37.
Yes, Chair, that's what I was looking on, even though there is blue at the end, but I'm just going to put it up on the screen here,
Yes,
Chair,
please.
so you can read
Yes.
from.
Chair, may I make an observation before you move on?
Yes, please, Mrs. Go ahead.
I have a concern, Chair, which I'm still unhappy about. I don't feel that it has been addressed, and that is in relation to clause 34, 3 and 4. Clause 34, 4 imposes a penalty of a fine not exceeding $1 million or in default thereof to a term of imprisonment not exceeding 3 months. It is imposed in circumstances where a respondent fails to comply with an award of the tribunal. There's a previous clause that says that an award made by the tribunal can be recovered summarily in the court without limit of any amount as a civil debt. So I have remained unclear as to the intention of the clause that makes it a criminal offense for failure to comply with an award of the tribunal. I'm unclear as to what time frame would be given to the respondent to apply, to comply, and within what context it would become a criminal offense. And I'm not satisfied with any explanation which has been advanced. And I think that I would ask the technical team to try and explain to me in particular, since why it is that we have that disparity in both, and how would someone know when it is deemed that the respondent has failed to comply with an award?
Who would like to take this from the technical team? Ms. Grant?
I'm sorry. So, Senator, I just want to make sure that I understand. You're saying that in 34.3, the amount can be recovered without limit of amount as a civil debt, and then 4 makes it a criminal offense where there's failure to comply. You're muted.
Yes. Remember, the failure to comply would be broad.
Yes.
Because the tribunal has powers to make all sorts of awards, including such award as may be appropriate in relation to the complaint.
Right.
I am saying, at what stage does the failure to comply become a criminal offense? And in what circumstances would a failure to comply become a criminal offense? In my view, you cannot criminalize this failure and subject somebody to a large fine and imprisonment unless there's clarity about it. And I am not getting the clarity.
Chair. I'm sorry, if I may. I think I'm agreeing with what Senator Scott Motley is saying. And I think that provision needs to be removed. And what happened, Senator Scott Motley, is that prior to us making amendments to this legislation that is coming to Parliament, these are matters that were decided by the courts. And these provisions were taken from the CARICOM draft, which is also in the Belizean legislation, which speaks to the court making a determination of an award, and it shall take into consideration same provisions we have, and where the court makes a determination, the sum shall be recoverable as a civil debt, and then any respondent who fails to comply with a determination for payment shall be liable to be proceeded against and be punished as if that person were guilty of contempt of court. So I think that is where this is coming from, which would make sense in a situation like this, but it definitely can't stay the way it is. I'm agreeing with you, the way it is drafted here. But I think it's because it was coming from another place. And of course, when we were redrafting, we omitted to amend this provision.
Thank you, Mrs. Healy Brown. It does not belong here at all.
Yes. So we will have to definitely delete subsection 4, subclause 4, I'm thinking.
Okay.
Thank you, Mrs.
So you got that, Mrs. McCarthy?
Just asking. Asking for some clarity in what we're deleting.
Asking for clarity on what?
What is being deleted?
Subsection 4. Oh, Mrs. Celia Brown, you were talking?
Yes.
Oh, okay.
Yeah. Mrs. McCarthy wanted to some clarification on what is being deleted.
34 subclause 4, that is being deleted, and the reason is, as Mrs. Celia Brown mentioned, was that initially the contemplation was that the courts would deal with these kinds of matters, but we're in 3 subclause 3, it speaks to it gives way to the civil aspect and the amount being recovered as a debt. To have the two, there's a conflict with the two provisions. So 34.4 would need to come out. I hope I made it clearer.
Yes.
Okay, good. All right, thank you, Ms. Grant. I see Senator Gale's hand up.
I just want to see clarity on something that I believe is very important to what Senator Scott Motley had raised. The tribunal making an award, and it's the respondent did not comply to the award. What provisions are there for the aggrieved to seek redress? And is it normally entrenched somewhere in a provision where for that protection? And I'm asking if any member of the technical team can respond, because there's a likelihood in instances where the tribunal may make an award and it doesn't follow through. That's I'm just seeking clarity on that.
May I ask the SG or Mrs. Cedar Brown to take that?
Chair, I'm thinking that is what subclause 3 is seeking to do. When you say it may be recoverable by the complainant.
Yeah, right. The issue is subclause 3 is only dealing with a monetary award and not any other award.
And not the other award.
Right.
And not the other awards. Not the re-employ, not the others outside of monetary.
So technically this could be addressed as contempt, and usually somebody can go to a court to have the court make an order, give direction that it must be complied with.
Okay. So do we need to just follow that approach, or do we have it prescribed in this?
So that I'm not clear on. That I need to just check. I'm not sure how the CPR rules deal with something like that.
Okay.
To see if we actually have to prescribe this specifically, or if rules of court just generally deal with it. So I would
Okay.
have to check on that. I don't know if Senator Scott Motley help. HELP.
Help, yes.
I was thinking in the same direction that you were, SG, that everybody has recourse to the courts if an award, if the award, the other types of award, we have made no provision for that. The only thing that concerns me is whether, since we have specified how the payment of money must be dealt with, if we should actually include the other methods of recourse in the legislation. Because certainly we have put that any person who is dissatisfied with the decision or award may appeal to the Supreme Court. So perhaps we should, the technical team needs to look at whether we should say that if there's no payment, or not payment, because payment is dealt with, if the award is not complied with, then recourse should also be to the Supreme Court, or whether it would be dealt with in the parish court. I think that, in other words, talking to myself and talking it through, I do think that we should make a specific recommendation, since we have actually said how one must be enforced.
Senator Scott,
I don't know what.
Senator Scott Motley, my only concern in this situation is that I understand and accept that the court would deal with the compensatory part. However, I'm not aware if in the layer of this, the court would be dealing with the reemployment.
Right, but you have to have a method by which, if the employer refuses to reemploy,
yes,
you can seek redress. Similarly, there are a host of other things, that ways and methods that the tribunal might seek to compensate, apart from it being monetary. And that's what I'm saying, that you have to have a pathway to redress. Now, the court you could make an application to the court for enforcement. You can always make an application to the court for enforcement of a breach of an agreement. But I think that once we have put in how the award for compensation must be dealt with, that we should also put in a clause that says where you can go, who you can go to,
who you can go to,
if the others are not dealt with. That was my thinking.
All right, fine. Thank you for allowing that discourse, Chair.
Chair?
So therefore, yes, SG, go ahead.
Okay, so
you're going to guide us now in making a decision. SG?
I'm pausing when you phrase it that way, but I found what I was looking for though. So in the CPR, the Civil Procedure Rules for the Supreme Court, it allows for the enforcement of awards made by bodies such like this tribunal, where if an award was made by the tribunal and not complied with, then an application can be made to the Supreme Court for the permission to enforce the award, to register the award, and then the court could then make an order in that regard, indicating that the award must be complied with. And it says if the award is for payment of money, so it addresses both money and any other award. So I take the point now by Senator Scott Motley that we have addressed one issue in here in dealing with the money, but not the others. And even to enforce a monetary award, that's already part of the rules of court. So it does seem strange that we have put one in the law and not addressing the others. I think we should either put all in or none.
And
because
so
it falls under rules of court, where an application can be made and it can be made without notice, must be supported by evidence on affidavit. That's a general rule, but I said a general rule will not apply if you have statutory provision requiring notice to be given, for instance. So this act could put something different in and deal with notice and all of that, separate and apart from what is already in rules of court. But just to reiterate, I'm not sure if I'm clear, that I think it's either we are going to put in the bill that you could approach the court for the enforcement of the award in the event the award is not being complied with, and the award would be whether monetary or not, or you leave it out and you leave it to the rules of court. I hope I'm clear. I feel like I'm not clear.
No, you're clear. You're clear in my mind.
Right.
You would have satisfied by way.
Yes.
Sorry, Chair. Sorry.
Yeah.
But Chair,
Sorry. Do you
Sorry.
want me to take Mrs. Seeley Brown and then I'll come back to you and Senator Gale? All right, Mrs. Seeley Brown.
Thank you, Chair. Thank you, Chair. I'm just looking at the Barbados legislation, and their section 22 maybe a little instructive in this regard. They provide for similar type of orders that we have, like what we provided for in clause 25. And then there's a provision which reads enforcement of tribunal decisions and orders, and it says where a person fails to comply with an order or direction given by the tribunal under section 16 or 21, that person shall be liable to be proceeded against and shall be punished in like manner as if he were found guilty of contempt of court. So they have just given a broader, they haven't separated it. They've just said if you don't comply, you are going to be treated in it as if you're in contempt of court and be dealt with accordingly. That's Georgia. That is the Employment Sexual Harassment Prevention Act, and it's section 22 of that act that you may want to look at. Through you, Chair.
Thank you, Mrs. Seeley Brown. I'll go to Senator Gale, then Senator Scott Motley.
So Ms. Aldred was clear in my mind, and I would be more inclined to accept an inclusion of some sort that makes a provision to treat with it, rather than leaving it open. So that would be my recommendation.
Okay, Senator Scott Motley.
Here, the provision which allows one to go to the parish court and in fact allows one to recover without limit the amount as a civil debt is, in my view, a very important provision. We have to look at it in the context of Jamaica and what is happening in our courts. And so I think that this particular provision should remain. And my preference is for the other awards to be addressed in a separate clause. But I think this will help. Any complainant will benefit from that. And that is what we're trying to do, to make the complainant, make it as simple as possible for the complainant to achieve redress. So I think it should remain.
All right, thank you, Senator Scott Motley. Mrs. Seeley Brown, I see your hand still up.
Sorry, Chair, I should have lowered it.
Okay, and I see Senator Gale's hand still up.
My apologies, Chair.
Okay.
Sometimes we forget to put our hands down.
Motley. All right, so we have to make a decision here. So I'm asking Ms. Grant, if you have captured everything that has been said, can you just summarize and then we make a decision? There's approach the court. There's 2 or 3 options are here. If you could.
Here, some things got lost in translation for me,
Yes.
I'm to be quite frank. But
you want to state what you have captured, and let's see.
But I think what I have come away with,
yes,
is that certainly the inclusion of the provision as to how it should be treated with if there's no compliance, and as to the forum, whether the parish court or the Supreme Court, I think I got the leaning that we're saying Supreme Court over parish court. Those are the things I came away with. I don't know if I've missed out some other stuff. If I have, then.
All right. I will ask Senator Gale what is his understanding in terms of what was his concern and what was put forward that would satisfy his concern. Similarly, Senator Scott Motley.
So my concern was in relation to how 34.1, the possibility of 34.1.3, if the tribunal was to make an award and the award, that aspect of the award would not have been enforced, and whether or not there would have been provisions that could be put in place to seek redress. And so I believe the Solicitor General had indicated a possible approach that could include a type of insertion to make such a provision. And I was inclined to accept that approach.
And that it was at that time Mrs. Celia Brown had read similar legislation from Barbados.
From Barbados. Mm-hmm. Which the legislation from Barbados, it's not really pointed, it's more overarching in my mind. Mm-hmm. Yeah?
Yes.
And then I was a little unclear in terms of what Senator Scott Motley had indicated, that what should remain.
All right, Senator. Thank you, Senator.
Chair, sorry, Chair. I think it would fit. It will fit better into the scheme of our legislation to do what Mrs. Aldred is saying. Just like how we've provided for the person who is dissatisfied to appeal to the court. In a decision, we can just add an insert of provision to say where an order is not complied with, that person may appeal to the Supreme Court and just move on. Because it does the same thing, and Senator Gale is right. Barbados scheme is a little different. It's more overarching, and it may not fit because we have already inserted certain provisions in here. So let's just go with that and just move on, Chair.
Thank you. Thank you, Mrs. Celia Brown. Members, committee members, we accept that recommendation and we can move on. Mrs. McCarthy, have you captured that for the report?
Minister, after we listen, because I got a little bit distracted with something else, so I will listen and fix it up right now.
I'm sorry, what could you repeat?
I was saying I will re-listen to the meeting at this point and fix it accordingly. I did not get the exact amendments, but I will adjust accordingly.
Okay, thank you.
Chair, just before we move on, what Senator Gale said, would that also encapsulate what Senator Scott Motley said?
Well, I think
it does.
Okay.
Yes,
okay.
It does, yes.
Chair, what the recommendation which the Solicitor General made is the one that I embrace.
That's right. Yes.
Oh, thank you.
All right, so it's now clear to you, Ms. Grant and Ms. McCarthy?
Yes, it's very clear to me, Minister.
Okay, fine. All right. So we are going to move on to clause 37, where it addresses offenses in relation to attendance at a hearing, and we note the observation regarding clause 37(3)(b) and on all the offenses throughout the bill that this clause that this clause has the same penalty regime for all the listed offenses, which gave the impression that all offenses have the same level of seriousness and thus should be accorded the same penalty. But I think that this was addressed.
Yes, Minister. I had asked Miss Grant to indicate to you before you got there that we could move past it. I think I just forgot to change the color on it.
So that was addressed. All right, so we now go to clause 38. Can you get it up? Clause 38, your committee also notes observation regarding clause 38.2. And on all the offenses throughout the bill, noting that this clause has the same weight, the same level of seriousness, and the same penalty as the other offense provisions. However, the offenses are different and may have different levels of seriousness. Your committee notes further the proposal that the penalty should therefore be adjusted accordingly. So I invite comments here just to indicate that the offenses need to have varying penalties as opposed to the 1 million. And I think that some of those have already been adjusted. So I invite comments here. Miss
Chair.
Yes,
yes, Chair. From my notes, Chair, I have that it has been adjusted.
Yes.
Because where we speak of 3 months, my notes have 12 months.
Yes.
So I'm noting here that it has, from my notes, we had agreed to adjust it, Chair.
Okay, fine. Very good. Now, on the general recommendations, Miss.
Sorry, Chair. So the adjustment to 38 to it, the monetary limit remains, and it was just 3 to 12 months. Mrs. Celia Brown, through you, Chair.
Mrs. Celia Brown, Ms. Grant was asking for.
That's correct, Chair.
Yeah.
I don't have a change in the penalty unless I missed it. I don't have a change in the penalty, Chair, unless I've missed it.
Okay, thanks.
Yeah. All right, Ms. Grant.
So I'm sorry, Minister, I just wanted to clarify, Mrs. Celia Brown. So is it that based on what I have here, we do not accept it, and we're only going to amend the part to say 3 months to 1 year instead? I wasn't clear on that part.
Well, we have agreed to amend if we're going to change from 3 months to 12 months. It's just that I don't have a change in the actual the fine, but the change that was made was in relation to the imprisonment term.
Okay.
We have accepted the proposal, and we have amended it to read to state that the term of imprisonment should not exceed 12 months instead of 3 months.
Okay, thank you.
Okay. All right. Ms. Grant, you're fine?
Yes, I am, Chair.
Okay, all right. So now we're going to general recommendations. And just to make a decision here, we note the proposal that the prohibition of victimization of employees should be considered. Ms. Grant, could you explain for me, for members?
Yes, Chair. So this came from the contribution of Mr. Makulu, and one of the things noted in what he addressed to the committee was that victimization of employees was not addressed in the Act. in the bill. I do remember when this came up in the meeting, the Solicitor General pointed us to, he said there's no remedy. The Solicitor General pointed us to the existence of certain pieces of legislation. It's in my notes. I can't lay my hand on it right now, but it was said by the committee members, the majority consensus was that where the bill provides for a criminal penalty if the respondent subjects a complainant to adverse action, that there is no recourse for the complainant to proceed to the tribunal if such adverse action occurs. It's just addressed where the respondent is dealt with criminally. And if I do remember correctly, it was a concern raised that possibly what could be done is that the tribunal could also have the authority to deal with any instances of victimization. So it's for the committee to decide if we would need to do that.
Senator Gale and Senator Motley, I'd invite you both to lead off with your comments there. Thank you, Ms. Grant, and invite other members.
Chair, I remember the Solicitor General in representing this matter. When I had raised the concern that it could be dealt with, she made reference to, I believe, the Jury Act, and there was another legislation to which we had recently passed that the provisions contained in that legislation could have represented it. I was just searching for it.
Disclosures Act,
Protective disclosure. Thank you.
Okay, Senator Gale. SG, please.
Yes. But I think, Chair, there are some provisions in the bill that should actually be considered before the committee decides whether anything further should be added. So currently, in clause 7.6, it says the employer shall not take any action which adversely affects opportunities, terms, working conditions of a worker who has instituted proceedings by way of a complaint, claim, or who has given testimony. And then clause 8.3 has a similar provision as it relates to institutions. So there is already some provision, there are provisions in the bill that address the point. I don't know if it is that the committee thinks those provisions are not sufficient, whether they should go further. And I think a part of the issue is these provisions relate to, for instance, the prospective employer and institutions, but I think perhaps the issue is that there is not a specific one. Actually, I'm not clear on why the issue was raised by the person who sent in a submission. Because as I look at 7.6 and I look at 8.3, I'm not sure if there is still a gap.
Thank you, SG.
When I look at 7.6, it is clear in my mind that this is a provision that would address it. It speaks to the employer shall not take any action which adversely affects the opportunities, that's one, terms and working conditions of a worker who has instituted proceedings by way of a complaint or claim under this act, or who has given testimony or otherwise participated in any investigation, procedure, or hearing initiated under the act. So it speaks directly to the person who would have represented a complaint or those who would have been possible witnesses in support of that complaint. So 676 is very, very broad as a provisional measure.
Chair, if I may just add to that, Chair.
Yes, go ahead.
And just to add to that, Chair, this is why I think again we need to move on, because on the clause 25, you can bring a complaint under any provision of any provision of clause 7. So you do have redress before the tribunal in that regard. So as it's covered, where you can go to the tribunal, it is also a criminal offense on the section that deals with adverse actions. It's covered on both sides, Chair.
And in addition to what Mrs. Seeley Brown said, Chair, 13 that deals with the jurisdiction of the tribunal to hear complaints addresses 7 and it addresses 8 as well. So it will be covered in both places. So it's already provided for.
Yes, Chair.
So you consider that it's adequately provided for here?
I would, Chair.
What was the point raised by the person who had sent in?
The essence of the submission was that that victimized, there was no recourse for the complainant to deal with issues of victimization, that it was only provided for criminally, and that would be as it is against the perpetrator. But what we have just put forward, Chair, it shows that that's not so, because 13 allows, if there's any adverse action on the 7.6, for the complainant to go 13 and 25 for the complainant to make such a complaint, and the tribunal can hear and determine, as well as 8. 8 is also allowed for. So then
it was Mr. Makulu, right? What was his recommendation?
Chair, if I may, he was referring to clause 38 specifically in terms of offense of adverse action.
Mm-hmm.
But I believe he may not have seen the supporting clause that makes detailed provisions in treating with the matter.
Good, thank you. Mrs. Simon? So your hand up?
Yes, I was just wondering, with regards to the accommodation persons, I don't see in clause 9 anything about adverse action for them. So I don't know, would it be prudent or necessary for provision to be put there as is in clause 7 and clause 8 for those persons, so that if they are victimized, they could raise that before the tribunal directly?
But how would that, Chair, through you, Chair, Miss Simon, I'm just wondering, how would adverse action, how would that apply in a case where you're seeking accommodation? I'm not sure.
They already have the accommodation. I'm wondering if they take action to try and sabotage it. Action that is adverse to you, I don't know, not doing repairs or things like that. I don't know.
And would that be a different action on the in another place? Else. Yeah, that's what I'm thinking. Would that be covered under something else? Because you would have signed an agreement in that case, and I'm thinking that you would have an action. I can't see that being an offense of adverse action in relation to clause 38. I don't know. I mean, I'll be guided, but I'm having a difficulty seeing it that way. Especially when we know that, as you be agreeing, that they would have redress in another place.
Okay, I was just wondering about them.
Thank you, Mrs. Simon. Ms. Grant?
No, Chair, I am okay.
Okay, so we're saying that the legislation adequately addresses that point.
Yes,
all agreed?
Aye.
All right. Now on the vexed issue of board members. The discussion regarding expanding the scope of the bill to include sexual harassment towards and by board members at this time. However, we know that the urgent need to address the matter, and the board, the committee, note the urgent need to address the matter and recommend that in the interim, that the necessary policy guidelines and a code of ethics be developed for oversight bodies to address concerns of sexual harassment towards and by board members, among other things. So do we agree that we are recommending that in the interim, the necessary policy guidelines and a code of ethics be developed for oversight bodies to address concerns of sexual harassment towards and by board members, among other things? Mrs. Celia Brown, I see your hand up. You wish to comment on this?
I think Chair, her hand was up from the previous point she made.
So committee members, do we agree that we will not expand the scope of the bill, but will in the interim ask that necessary policy guidelines and code of ethics be developed for oversight bodies? Do we all agree on this approach?
Chair,
Yes.
I recall Ms. Wilkins had made on 2 occasions representation to the committee around this matter, to which I believe at the time the committee had accepted. In furtherance of that, there was also an indication as to whether or not this matter could have been dealt with upon that time frame to which when the legislation would be reviewed. We took note of the fact that it's a very important issue. It's an issue that ought to be addressed, but it would change the overall features of the legislation if we were to, at this time, include provisions or amendments on the entire bill. And so I thought we had agreed that later on in the review, we would have dealt with it. That was my understanding.
Okay, so do we agree on the wording? Or should we include that at the revision of the review of the bill? Then that would be taken into consideration. Should that be added?
What if we add that, that would give some confidence in mind that there is the intention to treat this matter as a priority later on. Given the extent of representation that was made around it.
I'm in agreement, Chair.
Thank you, Senator Gale. I will take Senator Campbell Rodriguez.
Thanks, Minister. As you know, this has been an issue that I've lobbied hard for, and I still think it is of utmost importance. I understand from the last meeting the reason we have to defer it, but like Senator Gale, I think we should put a note here to include the fact that at revision, this is one issue that should be included and not pushed further again. So I'd like that to be included. And also in terms of interim, that the necessary policy guidelines and a code of ethics be developed. Do we have a time frame around that? Because what I don't want is for us to agree that that be done, but it somehow just slips through the crack. Because, you know, everyone gets really busy around all different kinds of things. So do we have a time frame for that? I think it would make me a little bit more comfortable if we had that.
Well, would you want this to be treated similar to the policy? The entities should have a policy developed, and so the code of ethics would also be a part of that. And within that context, the time frame we have established already.
Right. Sorry, I might be missing what you're saying, Minister.
The time frame that's already established for the policy guidelines.
Right.
The code of ethics could also be tied to that. That's my opinion. Senator Gale,
Agreed.
you may wish to comment on that. I see Mrs. Celia Brown's hand up. I don't know if it was all along or if she wants to make a comment as well.
It is at these times that I miss Miss Rob, where her intervention around the development of the code of ethics that would include such provisions would help.
Well, Miss Rob, it should be with us.
Yes, yes.
Mrs. Rob? Yes, Mrs. Robinson is with us.
Oh, so okay.
We could ask her to make her input here. Mrs. Robinson?
So sorry, Minister. I was dealing with another matter. Could you just remind me of what it is, what specific?
Yeah, we're speaking, let me just read it. Your committee does not agree to expand the scope of the bill to include sexual harassment towards and by board members at this time. However, we note the urgent need to address the matter and recommend that in the interim, that the necessary policy guidelines and a code of ethics be developed for oversight bodies to address concerns of sexual harassment towards and by board members, among other things. And it was raised here that there should be some time frame. And since there is some guideline for policy, recommendation for policy guidelines to be developed, so possibly the code of ethics could also be tied to the fact that the policy guidelines have to be established within a certain time frame. So Senator Gale was indicating that he would welcome your input here.
Okay, thank you, Minister. I remember the conversation we had at the last meeting where the recommendation was that we could speak with or have conversations with the private sector to provide assistance regarding the development of a code of ethics that would allow to replace or sort of, not replace necessarily, but to sort of substitute for the fact that we would not be providing something outside of the schedule. So in the schedule, we put the draft sexual harassment policy. There's a guideline in here that speaks to how it is that the policy would be developed, the sexual harassment workplace policy. And I think the agreement was that that would be sufficient to guide any development of any policy that each workplace would come up with in terms of the parameters of that policy being guided by the sexual harassment workplace policy. So that code of ethics, I think I recall the conversation was that we could actually get some support. The Bureau could work with groups, whether private sector or otherwise, or have a consultant develop through the guidance from the technical team, as well as the guidance from the policy and other bits of legislation that would have had similar types of guidelines to develop that code of ethics.
Okay, now I think Senator Campbell Rodriguez was asking, well, we were asking for two things in this particular paragraph to indicate that this would be done in the interim, and that when the legislation comes up for review, then the question of harassment towards and by board members would be included in that review. And Senator Campbell Rodriguez was asking for a time frame in relation to the development of the code of ethics. So those two things could be included in this paragraph with just a little expansion. Mrs. Robinson, I don't know if you have any suggestions there, or if Senator Gale or Senator Campbell Rodriguez or any other member would wish to expand that paragraph to include those things, those two things.
I think I could be guided, Minister, by the technical team, because I remember the conversation about 6 months or a year, and I also recall us speaking about perhaps shortening the review period to bring it earlier. And so between the time we have this one approved and to actually do the review of this particular legislation, we could have the development of whatever it is that is required. So I would be guided at this point by the technical team and the members of the committee.
So can I call on a member of the technical team to guide us here? Or if Ms. Grant would like to take this in relation to the expansion of this paragraph to include those two things? Ms. Grant?
Minister, I'm not sure what guidance is actually being sought.
To include a time frame for the development of code of ethics. I'm trying to remember now, did we include a guideline for the sexual harassment policy?
I think it was in 1 year. I think it was 1 year.
So I'm saying that the code of ethics in relation to boards could
also the same 1 year
within that context, right? So that would be just added to this paragraph. And also the fact that the legislation would come up for review where the question of harassment towards and by board members would then be taken into consideration.
Right.
So we just need to put the wording in there to be more specific. Well, so Senator Gale, you want to finalize the wording here?
Chair, I'm just suggesting that we just could include the commitment to for the ministry and the private sector or stakeholders to work on this code of ethics. So what we really need is a commitment that this is going to be done.
Okay. Senator Campbell Rodriguez? Mrs. Celia Brown, you wanted to make a comment?
Yes, Chair.
Please go ahead.
Because I'm understanding, Chair, that we had said that we would have agreed to look at the whole issue with respect to board members pursuant to Section 42 of the Act, where we were going to shorten the review of the Act from 5 years to whether it's 6 months, 12 months, whatever. So I understand that. But when you speak of putting code of ethics into the legislation, we can't just put in a code of ethics to deal with that particular issue without anchoring it somewhere. And I don't see nowhere, Chair, because even when you speak to the policy statement that we're referring to, it speaks to an obligation to an employer. So I don't know where we are going to. I'm still in my mind trying to see where we're going to anchor that provision that deals with code of ethics, Chair. That was not my understanding. My understanding was that we shortened the review period under clause 42, and then when we look at reviewing the bill at that point in time, we think of incorporating. Of course, our policy would have been sorted out at that time. We would have developed our policy around how do we treat with board members, who are board members, how are we extending it to other bodies that may not be boards under the legislation, and then at that time seek to incorporate it into the review legislation. Yes. That was my understanding, Chair.
Yeah, that was the understanding, but I think Senator Natalie Campbell Rodriguez really was posing a different question. All right, so Senator, go ahead and just repeat what you were asking.
Right, thanks. I was just saying in terms of specifically to what's written on page 46, where it says, however, we note the urgent need to address the matter, and the matter being that of board members, and recommend that in the interim that the necessary policy guidelines and a code of ethics be developed for oversight bodies. So I wasn't referring to the policy guidelines in general, But here where it says the one to be developed for oversight bodies to address the concerns. That's what I was talking about.
So therefore, Chair, I understand the point that is being made. So it's not that it is to be incorporated in this legislation, because we can't just, right, because we can't, we'll have to anchor it in some provision, which we can't because the Act does not provide for that. So I take that point, and then in developing the policy guidelines, those codes can be developed outside of the legislation. And if when we come to if when we come to review, what we need to decide, Chair, is what is going to be the review period when we get to it in clause 42. And then we will determine when we're reviewing it then how and well, not how, yes, how, because you have decided that you would want it incorporated. How are we going to incorporate it in the legislation?
Madam Chair, if for Mrs. Seeley Brown, so it's two things. Here, I was also asking for us to ensure we put a note here to indicate that it shall be reviewed in that first review process. Don't just leave it silent, because some of us may not be in this position on this committee again. So put it there, and also a timeline around which this specific code of ethics will be developed for the oversight bodies.
For the interim period.
Okay.
For the interim period.
Okay. So what we can do, may I suggest, Chair, what we can do is that when we get to 42 and we make a determination as to the time, we then state that Senator Campbell's concerns that in reviewing, we would look at sexual harassment against board members and like bodies. So we can put that in at that point in time, Chair.
Okay.
I'm sorry, Chair, just to indicate on the timeline issue, I remember the last meeting, if not the last meeting before, we were looking at the review period of 3 years.
Okay.
That's also my memory, that it started at 5 and we agreed that it would be 3 years. That we would do the review. So I thought something else had happened that I had missed while we were looking back at it again. But I just, not to flog the point, but I would also love for us to agree on a timeline for when the code will be developed for the oversight bodies to use in the interim.
I think
I'm sorry to jump in here, Chair, but the 3 years, the 3 years sounds, because I remember when Miss Wilkins was making her intervention, and I know the time had to be, it was suggested, and I know the committee agreed to a shorter period, but because of these outstanding issues, which the majority of the committee members want to be addressed, 3 years still seems long if it's supposed to be done in that review, exercise. Let me put it that way.
I agree, Chair. I agree that 3 years is too long.
But you need 18 months.
You won't hear me complain.
Chair, Ms. Wilkins is suggesting 18 months.
Sorry, and Chair, just to clarify, normally I'm on the other side of this, because normally when we're going to review legislation, normally we would want more time to see how it works. But remember now, the consideration is being given to those outstanding matters, because I don't think it was just about boards and like entities. There are 1 or 2 sort of outstanding policy issues that the committee members have strong views about. And it was in that context that, as I understand it, a compromise is sort of being given to say, look, let's try to address some of those matters during the review exercise. Now, if those outstanding policy issues are to be addressed during that review exercise, then it has to be a shorter period. My own view, it really would have to be a shorter period.
Well, you know, SG, I would agree with you. However, you know, the technical team would also or must take into consideration that you would be called on. And but I would imagine that we can work with 18 months. If that is what
perhaps then Ms. Wilkins, because legal reform would be playing a big role. So perhaps, but I do recall Ms. Wilkins agreeing to even a shorter period than, remember it started out at the 5 years and it was even shorter, but 3 is still too long. And Chair, we know our role, and
Yes.
we're going to do our work when we're called upon, and even when we're not called upon. So you don't worry about that aspect.
In spite of the pressures.
Yeah, we I don't want to call it pressure. It's part of our role, so we will undertake it. So it's just for the committee to come to decide what they think is also a reasonable enough period.
Chair.
Yes, go ahead,
Ms. Perkins is suggesting 18 months if the committee so agrees.
Committee so agree. I hear no objection.
No objection here.
All right, great. Thank you so much. That one was very easy.
No objection.
No objection, no objection. Okay, so in relation to the board, will we just accept what's written here? Or
Minister, just to add the part about it, I don't know if we put it here or further around where we indicate that in the revision, that should be one of the things on the agenda.
Yes, where would we put this, Miss Grant, Miss McCarthy? Would it be included in this paragraph, the 18 months?
We could put it right here.
Yes,
right here?
Yes.
All right. So Miss Grant, you want to give us the word in here?
Minister, just to say that the committee did agree, because it starts out to say that committee does not agree. Say that the committee did agree that issues, well, that is it that we're going to meet in the 18 months to determine how we incorporate boards into the legislation?
Georgia, it is going to be wider than that. It would be a complete review, Georgia. But what Senator Rodriguez Campbell wants to ensure is that when we are doing the complete review, we specifically deal with board members and but it would have to be a complete review.
Okay. Then, Minister, I would say that the committee did agree to a review period of that the first review of the legislation be undertaken within 18 months. Yes. for a complete review to be undertaken within 18 months, and
that this review would include
would include, among other things, issues relating to harassment towards and by board members, something like that.
Yes. Ms. McCarthy?
Yes, Minister. So we're not agreeing to the policy guidelines anymore. We're just agreeing to the first review of that matter.
No, we are also to the policy guidelines and code of ethics in the interim.
Yeah,
but we're just adding the 18 months. The 18 months review.
Minister, if I may?
Sure, please.
I'm just saying to Ms. McCarthy, we're keeping what is there now, and we just need to add in a line about the future review and ensuring that the future review looks at boards.
Okay.
So we're keeping what's there and adding.
Okay.
That's my understanding.
And the inclusion of the development of the policy guidelines within the 1 year, that would also be included.
Yes, and the code of ethics in the interim.
Yes.
Chair.
Yes, Mrs. Seeley Brown.
May I just ask a question before we move on in relation to the policy statement? And we keep saying that we are going to be inserting this guideline in the schedule, Chair, which would take us back to, I think it's clause 4. So I just wanted to find out, Chair, if because you notice we are very we have expressed very clearly what the policy statement of every what the policy statement should contain, but an employer should ensure that the policy statement contain. When we speak of including something in the schedule, then Chair, I think this is for Mrs. Coburn. What is it that we're going to be included in the schedule? How am I to link it back to clause 4 of the bill, Chair?
Mrs. Robinson? Mrs. Robinson, could you respond to this, please? Thank you.
Okay. Mrs. Cedar Brown, could you just ask the last part of what you said? Because you said quite a few things.
Sure. I'm just saying that when we speak about incorporating these guidelines in the schedule, how are we tying it back to clause 4.3, since we are so expressive in what this policy statement must contain? Is it that we set up a template, or is it that we providing guidelines as to how these things must be included in the policy statement that is supposed to be developed by the employer?
I think we're looking at the song. I think we're looking at template and where it is required to do over and above what is already existing, that we will develop in addition to what is there, what is required. So if it needs to go further, then that would allow us to develop it further. But where what we have is sufficient, we would use what is existing.
So it would be that it would be that the policy statement would provide for what is there and whatever is provided for in the schedule where applicable. Is
That's correct. That's my take on it. That's how I think it should. That's my recommendation.
Okay, thank you.
You're welcome.
Thank you, Chair.
Good. Okay, so Ms. Grant?
Yes, Minister, that takes care of
well, just before you go, Ms. McCarthy, you have a clear understanding so far?
Yes, Minister.
All right, Ms. Grant?
Yes, Minister.
Okay, so could proceed now. Take us to where you need to take us.
We would resume then, Minister.
I really want to thank everyone for their input in making us go through the areas where we needed to make decisions and for us to have made these decisions so quickly.
I'm sorry, I don't know who. There were some members who had joined after you had indicated initially about the break. So I'm not sure if you would want to revisit.
I'm sorry, could you repeat that?
I was saying that you had indicated initially that there would be a break at some point in time, and some members joined the meeting thereafter. So I'm not sure if you want to highlight that.
All right, we were looking at taking a break at 1:30. It is now 1:15. Maybe we should take the break at this time. And then when we come back, we do a complete, well, we pick up where we left off.
Which is from clause,
Clause 10?
No, clause 11, Chair.
Clause 11.
What I have here on the screen.
And we should be able to go through the rest of the report quickly.
Madam Chair, is the break half an hour or 1 hour, just to be sure?
I would say make it a half an hour. We break at 1:50. We break now, which is 1:15. We come back at 1:45. And we work until we have completed the report.
Noted.
Okay, our technical team, our legal team, you're fine with that?
I'm fine with it, Chair.
All right, thank you. I think we got a lot done so far today. And so hopefully we would go through the rest of the report and be finished before 6 p.m. We have an extended period, but I think we can go through quickly because we would be going through the clauses that we have already agreed on. So I just want to, at this point, indicate that we take a break and to thank everyone for their contribution so far. And we'll see you back at 1:45. Agreed, members?
Agreed, Chair.
Agreed.
Thank you. Thank you. All right, see you in a little while. Enjoy lunch. Use the opportunity to go through the report while you're at lunch. Thank you.
Jamaica, I can